Big breaking news coming out of the courtroom in Dedham, Massachusetts, as the Honorable Beverly Cannone has taken the bench and begun this morning's hearing with her findings relating to the question of whether a fraud was perpetrated on the court by Karen Read's defense team. The judge starting out by saying she's found repeated misrepresentations deliberately made by defense counsel. We're backing up the tape. You're going to watch it all with us now.
All right, so we have a lot to cover, but what I'm going to start with is a decision on the Commonwealth's motion to exclude employees of ARCA. So I think I told counsel before that I had reviewed, so first we had full hearing from counsel. I heard from the lawyers. I heard from Mr. Alessi on behalf of the lawyers. I've read the transcripts. I've listened to the sidebar conference and read that transcript. And I've certainly read the pleadings. So based on all the evidence, I conclude that there has not been the candor required of all lawyers has not been demonstrated here. I find that there have been repeated misrepresentations made to the court by defense counsel, and I conclude that they were deliberate concerning the relationship with the ARCA witnesses. They were made at sidebar, in open court, and in pleadings. And I think the record is pretty clear, and I find that on July 25th, 2024, payment was made to the ARCA witnesses. Yet on February 26, 2025, in a pleading written by Ms. Little, signed by all three defense counsel, says the Commonwealth's motion to exclude these exculpatory expert witnesses, ARCA witnesses, who were not hired or paid for by the defense, is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. The next page. Ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCA witnesses as ordered by the court. So I find or conclude that that was a material misrepresentation and that it was deliberate. So I find that there is a flagrant violation of the Rule 14 obligations, and before I decide which sanctions are appropriate, I need to see defense counsel and Ms. Read at sidebar. I'm going to ask that the Commonwealth remain where they are. I'm going to seal this sidebar, but I need to have a colloquy with Ms. Read before I figure out exactly what I'm going to do here. So.
The judge concluding material misrepresentations that were deliberately made by the defense. And she's saying before she decides which sanctions are appropriate, she wants to do a colloquy with the defendant and see just the defendant and her counsel at sidebar, not the Commonwealth attorneys. What might the judge be saying? Let's bring back in Attorney Rick Grundy and investigator Claudia King. Rick, what might the judge be saying to them right now?
Well, for anybody who didn't catch that, a bomb just went off in the courtroom, huge bomb. And what she's saying, I suspect, to Ms. Read at this point in time, is that what your attorneys have done is to pull a falsehood on the court. And you need to, or I need to, make sure that you are comfortable with their representation, that it's your intention to go forth with their representation, and that you now know, because I have questions with respect to their integrity that put on the record, whether they are communicating with you as to the situation that they have created as found by the court. It's a big problem. And are you aware of it, the magnitude of it? Do you want to consult other counsel as you go forth in this matter?
Right, Rick, because the issue is, do you want to go forward with attorneys who have perpetrated this, which she called a flagrant violation, material misrepresentations deliberately done? Claudia, your reaction to, as Rick very appropriately deemed it, a bombshell. This is a bombshell, without a doubt. Your reaction, please, Claudia.
This is absolutely devastating to the defense's case, and it's devastating to these attorneys' reputations. The one thing that everyone walks into that courtroom with is their integrity and the ethics to do right in the courtroom, and they have just thrown that all away. So this is huge. This is a bombshell, and where are we going to go from here? Because we know that Judge Cannone does not want any more delays in this trial, but if we have to look at new counsel, then we're definitely looking at a delay. So this is very, very interesting, and it's a bombshell, like Rick said.
It sure is, Claudia. You know, I mean, it could be removal of the attorneys, could be fines, could be a number of things here. Let's go back in. The sidebar has concluded. Let's see what's happening next on the record.
So there's no greater constitutional right than the defendant's right to a fair trial, including a fair and impartial jury, the right to present a defense and confront witnesses, and the right to counsel, which includes counsel of her choice. So I've just had a thorough colloquy with Ms. Reed. I believe it was extensive and thorough, and she has expressed to me a strong desire to continue with her lawyers. Ms. Giannetti, is Mr. Jackson lead counsel? I just want to make the record clear. Mr. Jackson, are you lead counsel?
We don't define our roles in such a manner, Your Honor. Okay,
so because Mr. Giannetti is not pro hoc vice counsel, and Mr. Giannetti can try this case if need be by himself. All right. But Ms. Reed does have a strong desire to keep all of her lawyers, notwithstanding the Rule 14 violation and the apparent lack of candor, the findings and rulings I've made. So, based on that, I am not going to revoke pro hoc vice licenses. I don't expect to have to address this again. Candor with the court is essential. It's the bedrock obligation of all lawyers who appear in this court and all courts in Massachusetts. A lawyer is only as good as his or her word, and I need to be able to take counsel at their word. So I'm not going to tolerate false statements, any stretching of the truth, no misleading distortions. There's no place for that in the courtroom. And Mr. Jackson, you stated this very eloquently in your closing argument last time. So, Commonwealth, I am denying your motion to exclude the ARCA witnesses. Those witnesses can testify as long as counsel complies with their reciprocal discovery obligations. I will allow a full cross-examination, Mr. Brennan, and I will review any proposed curative instructions, limiting instructions, or final jury instructions. So that's my ruling on that. So we'll move on to...
The judge emphasizing that there has been a lack of candor to the court by Karen Reed's defense team, and that she did a colloquy, which is a fancy word for a question and answer session with Karen Reed that was very thorough, asking her, despite knowing that your lawyers were not honest with the court about this, do you want to keep your lawyers? And she does. I'm not surprised at that she wants to keep them. Some of us may seem a little surprised that the judge didn't go ahead and just impose a sanction, something more severe. But maybe the judge is looking at the long game here. What would that mean if she did remove one of those attorneys, if she did remove the pro hoc vice status of any one of them? David Yannetti, she knows, is the only one who's licensed to practice in Massachusetts. Then what happens? If Karen Reed's convicted, then does the case come back on appeal? Still with me, Claudia King and Rick Grundy. Rick, you practice in the Commonwealth of Massachusetts. Do you think that's the judge's thinking, that a severe sanction could create a problem down the road, in this case coming back into her courtroom?
Absolutely. You know, you have two very powerful forces coming to bear here, and they kind of work against one another. And unfortunately, in my opinion, very often in cases like this of egregious behavior found by the court, the sanctions or lack thereof don't meet the actions. And for that reason, they don't play a part in curtailing further actions. That force, the desire to create that cause and effect, bucks up against that, especially in a homicide trial, the right and the desire of the Commonwealth to recognize the right of a person to have representation of their choice. And that is a situation, if she were to say, and she could, you know, the twist here is this pro hoc vici. Jackson and his associates' rights to be in the Commonwealth of Massachusetts representing her are very tenuous, and she could pull those very easily. However, she knows that's going to be a huge appellate deal down the road for her not having the counsel of her choice, full knowing what they did to the court.
Right, right. Well said, Rick. What about the stink that is left after this? Claudia, let's talk about that because it leaves a real stench knowing that one side wasn't honest in the court, where you have to be honest. You take an oath to be honest. As a lawyer, you're an officer of the court. Claudia, you know this. Does it have any bearing going forward? What do you think? Does it leave anybody watching this case with a bad taste in their mouth?
I think it absolutely does. And the other issue that it brings is in this second trial, when there are motions or objections, the judge is going to remember this. And if there comes an issue where integrity is in question or there's a possibility of who's telling the truth, this is going to be on her mind. And the fact that there have already been issues with truthfulness with the defense counsel is going to be on her mind. So I think it is going to be a potential issue in this retrial.
I'm with you, Claudia. I'm with you. You know, and if you're on the side of the Commonwealth, I'm sure you are watching very closely to see about every representation made that it is a truthful one. The judge, if anyone's just joining us, Judge Cannone has issued her findings and her conclusion to the question of whether a fraud was carried out on the court. And she said her words, she found material misrepresentations by Karen Read's defense team to have been deliberately done on the court, that they violated their duty of candor. They violated what is part of the rules of criminal practice in this court of law, that yes, they have violated it. She called it a flagrant violation. And in terms of what sanctions are appropriate, she has a lot of options. But here she's allowing Karen Read to go forth and continue with these attorneys who were not completely honest with the court at the last trial.